with surveys showing that around 80% of PTAB proceedings have parallel district court litigation. It seems like PTAB is used, obviously, as an alternative to district court litigation, but we have a different standard of proof. And PTAB employs a lower standard of proof than district court litigation. And do other witnesses agree with Mr. Bright that we should have more of a parallel standard of proof?
Well, this is Dave Kapos. Thanks for the question. I would just say I do agree. We have definitely learned with the PTAB taking on such a dominant role in being the forum in the U.S. that decides patent validity, that its standard of proof needs to be aligned with that of the district courts, which is the clear and convincing evidence standard.
And would that help with your estoppel situation?
Well, it's a different issue from estoppel. It would likely result in petitioners being more circumspect about bringing PTAB challenges in the first place, though.
Okay. Do other witnesses have anything to say about aligning the standards of proof?
This is Joe. I hate to disagree with anything about anything with Mr. Kapos, but I do have to disagree on this issue. When this issue was actually discussed when the AIA was developed, it was actually the USPTO itself, the agency during the Bush administration, that most strongly argued against a clear and convincing standard. The rationale for that standard is the district court applies it because it's deferring to the agency's expertise. When you go before the PTAB, it's the same expert agency that it was before. In fact, when the PTAB is making its decision, it has much more time to analyze the decision, and in virtually every case, it has prior art that wasn't before the examiner. So when you're making a decision twice, and the first time you only had limited information and less analysis, the second time you have more, when you have more information, why would you defer to what you decided the first time? You're the same person. The decision that's made by the same expert agency that has more information in front of it at that time should be the final decision.
Congresswoman, if I may add to Mr. Mittal's point, I disagree completely because the federal rules of evidence are not in place and you don't actually have more information. You've not gone through discovery, you don't have access to source code. All of that may be highly operative to whether or not the technology is novel.
It's been said here today that it's more accurate. Mr. Rogers, can it be more accurate if it doesn't allow discovery? And how, you've been through PTAB and a court case, is that correct?
We have.
And how did discovery, the ability to have discovery, change the decision or influence the decision of the judge or the jury?
Well, a telling example is Cisco made certain arguments that our patents were obvious. We went through the PTAB. And when we ultimately got discovery, we got access to emails that said we need to go and study Centripetal's patent claims. That was a pretty telling and jarring example. And source code tells a very different story about when technology was implemented and why than just looking at some reference.
And do judges take that into consideration when they make a determination of obviousness, for instance?
At the PTAB, they do not.
But in the courtroom, they do?
In the district court, you have the full benefit of that.
Any other witness want to respond, share their formula for changes to the PTAB?
Mr. Johnson, I would suggest something that's actually I understand is going to be a topic of one of your upcoming hearings. About a year ago, this committee asked GAO to investigate allegations of political interference in post-issuance proceedings at the board. I understand a report's coming forward shortly. It's likely that that report will raise troubling questions about the independence of the board. These cases are very valuable to the parties. You really want an independent decision maker making these decisions. The board used to have structural independence. This came up in the briefing in Arthrex that before 1975, all PTAB judges, they were then called examiners-in-chief, were appointed by the president and confirmed by the Senate, as all military officers still are today above the level of captain. The committee may want to think about returning to that structure or something else that guarantees independent decision-making by the judges without anything going on behind the scenes. You really want that expert judge exercising their own judgment about the facts and the law before them.
I appreciate your comment, Mr. Mittal. And in fact, it sounds like you're advocating for a district judge to make these decisions, which is where we were before 2012. And of course, I was accused of being concerned about the bill back then simply because I had a lot of litigation in my district in East Texas, that was the patent troll capital area, when actually the reason a case got filed in the first place, it was not an individual inventor or patent troll, it was something called Texas Instruments, and they were desperate to find a place where they could get a trial less than 5 years and get some conclusion, and they did that. And then as people found out there was not only a brilliant lawyer judge there, but also he was an engineer, then more and more people began to file there. And it seemed to me that an 18-month to 2-year average was not bad for a district court. And I understood we had a problem with patent trolls, and it was a real problem. But I could see from reviewing the legislation back then, wait, this isn't going to fix the patent troll situation. But it got passed, and then 3 years later, we were provided more legislation and go, we're going to have to fix this because we got a problem with patent trolls. And you know what? It turns out that legislation didn't fix the problem. And we've had that a couple of times, actually. Gee, we got to fix the problem with patent trolls. That bill in 2012 didn't really fix it. And now we're dealing, and I really do appreciate this hearing because we're getting to the crux of concerns that some of us had 10 years ago. And since then, having heard from so many individual inventors about the very thing, Mr. Rogers, you just outlined, this hasn't made things faster. It hasn't made things more quick. And in fact, instead of having a more independent decision made, we seem to have more political effects being made. So these are things that need to be addressed here in Congress. But I would yield to my friend, Mr. Massey. For the rest of
Thank
the
you.
time.
I have